The marble columns of the Supreme Court hearing room seemed to amplify every sound as cameras captured the tense atmosphere of the judicial oversight hearing. What had begun as a routine congressional review of judicial ethics standards had suddenly veered into unexpected territory. Supreme Court Justice Samuel Alito leaned toward his microphone, his expression shifting from judicial stoicism to barely concealed derision. The C-SPAN camera zoomed in as he removed his glasses deliberately, a gesture that immediately commanded attention from everyone in the packed chamber. "Congresswoman Crockett," Alito began, his voice carrying the weight of his 16 years on the nation's highest court, "I've sat patiently listening to your lecture on judicial ethics and constitutional interpretation for nearly 10 minutes now." He placed his folded glasses on the table with precision. "But I feel compelled to address a fundamental misunderstanding in your characterization of our recent Carter v. Montgomery decision." The cameras panned to Representative Jasmine Crockett, who maintained her composed expression despite the justice's unmistakably condescending tone. "You've claimed that our ruling, and I quote directly from your earlier statement, contradicts established precedent on administrative agency authority dating back to Chevron," Alito continued, a slight smile forming at the corner of his mouth. "This assertion reveals a concerning misapprehension of constitutional jurisprudence that I would expect from a first-year law student, not a member of Congress questioning this court." A murmur rippled through the chamber as Alito's voice took on an increasingly dismissive tone. "The distinction between these cases is so fundamental to constitutional law that I'm genuinely surprised we need to clarify it in this forum." The justice actually chuckled audibly, a sound rarely heard from the Supreme Court bench, before continuing, "Perhaps the Congresswoman might benefit from revisiting basic principles of administrative law before presuming to lecture this court on precedent." Committee members shifted uncomfortably as Alito's unprecedented condescension hung in the air. The committee chairman, clearly caught off guard by the justice's tone, glanced uncertainly between Alito and Crockett. "Representative Crockett, would you like to respond to Justice Alito's clarification?" the chairman asked, struggling to maintain the decorum expected in congressional hearings with Supreme Court justices. The cameras focused on Crockett as she calmly gathered several documents from her portfolio. Her face revealed nothing as she adjusted her microphone, the contrast between Alito's open derision and her measured composure striking even before she spoke a single word. What happened next would not only dominate legal news for weeks, but would fundamentally alter public perception of both Alito and Crockett in ways neither could have anticipated when the hearing began. Don't miss any of our Political Truth videos. Hit the like button and subscribe now for more revealing confrontations that expose what's really happening in America's corridors of power. Representative Jasmine Crockett hadn't arrived in Congress via the conventional path of most politicians. At 45, the Texas Democrat had built her reputation through a distinguished legal career long before entering politics. With degrees from Rhodes College and the University of Houston Law Center, Crockett had practiced constitutional law for 15 years, arguing cases before federal appellate courts and authoring amicus briefs for 2 Supreme Court cases. Her transition to politics came after successfully representing community organizations challenging voting restrictions, work that had established her reputation as a meticulous constitutional scholar with particular expertise in administrative law and regulatory frameworks. Legal colleagues had been surprised when she announced her congressional run, expecting her to continue her rising trajectory in constitutional litigation. "The law isn't just interpreted in courtrooms," she had explained during her campaign. "It's shaped by legislation, and I believe I can better protect constitutional principles by helping craft laws that withstand judicial scrutiny." This approach carried into her committee assignments, where she had developed a reputation for precise questioning, grounded in legal precedent, rather than political talking points. While this sometimes frustrated party leaders hoping for more partisan messaging, it had earned her respect from legal scholars across the political spectrum. She approaches oversight hearings like oral arguments, one former clerk for a conservative judge had noted. She comes armed with cases, not just opinions. Justice Samuel Alito represented a markedly different legal philosophy and temperament. Appointed to the Supreme Court in 2006 after serving on the Third Circuit Court of Appeals, The 73-year-old jurist had established himself as one of the court's most conservative voices. Known for his originalist approach to constitutional interpretation, Alito had authored numerous opinions limiting administrative agency authority, including the recent Carter v. Montgomery decision that had become central to the current hearing. Over recent years, Alito had become increasingly outspoken both in his judicial opinions and occasional public appearances. Legal observers had noted his growing willingness to express frustration with perspectives he considered insufficiently grounded in his preferred constitutional interpretation methods. Justice Alito has become more vocal in defending his judicial philosophy, observed constitutional scholar Rebecca Michaels. There's been a noticeable shift from judicial restraint in his public communications toward a more assertive defense of his interpretive approach. The conflict between Crockett and Alito had deeper context beyond their different backgrounds. 3 months earlier, Crockett had published a detailed law review article analyzing Carter v. Montgomery in the Harvard Law Review. The article, widely circulated among legal scholars, had methodically questioned the majority opinion's departure from previous administrative law frameworks, suggesting the ruling represented ideological preference rather than consistent legal reasoning. Though Crockett had maintained scholarly tone throughout the article, her conclusion that the decision appears more aligned with preferred policy outcomes than established jurisprudential principles had clearly touched a nerve among the decision's defenders, particularly its author, Justice Alito. The stakes of the current hearing extended beyond personal conflict. Congress was considering legislation to clarify administrative agency authority following the Carter decision, which had significantly restricted the Environmental Protection Agency's ability to interpret its statutory mandate. Crockett had been instrumental in drafting this legislation, drawing on her background in administrative law to craft language that could withstand judicial review. For Alito, the hearing represented an unusual position, being questioned about a decision he had authored by someone who had publicly criticized its legal reasoning. Supreme Court justices rarely faced direct congressional questioning about specific rulings, making the current situation particularly uncomfortable for a jurist accustomed to having the final word. In the hearing room sat Professor James Henderson, a constitutional scholar who had taught both administrative law and separation of powers doctrine for 30 years at Georgetown Law. He had been invited as an expert witness for later testimony, but was observing the current exchange with professional interest. Beside him sat Marcus Washington, a former Supreme Court clerk who had worked on cases cited in both the Carter decision and Crockett's analysis. For them, this wasn't merely political theater, but a substantive debate about fundamental principles of administrative law and constitutional interpretation, principles with significant implications for how government agencies functioned and how courts reviewed their actions. As Crockett prepared to respond to Alito's dismissive characterization of her legal understanding, the atmosphere in the hearing room reflected the unusual nature of the confrontation. Supreme Court justices typically receive deferential treatment from legislators regardless of political differences, making Alito's openly condescending tone, and whatever response Crockett might offer, a significant departure from institutional norms. What's your view on how Supreme Court justices interact with Congress? Have you noticed a change in the tone of these interactions in recent years? Share your thoughts in the comments below. We'd love to hear about other memorable exchanges between our branches of government. Thank you, Mr. Chairman, Crockett began, her voice measured and even. And thank you, Justice Alito, for your candid assessment of my legal understanding. The subtle pause was the only indication of reaction to Alito's condescension, as Crockett maintained the professional demeanor expected in congressional hearings. Rather than responding with matching derision, she took a different approach entirely. Before addressing Justice Alito's specific points about Carter v. Montgomery, I'd like to clarify the foundation of my analysis, she continued, removing a document from her portfolio. I'm referencing the court's own jurisprudence on administrative deference, beginning with Chevron, but continuing through Meade, Kissor, and most recently, American Hospital Association. The precision of these citations, all major administrative law cases, caused a slight shift in Alito's expression, barely perceptible but caught by the cameras. He had clearly expected either defensiveness or political rhetoric, not this methodical legal response. "My concern with the Carter decision isn't about its outcome specifically," Crockett explained, "but rather about its analytical consistency with this established body of precedent." She placed a document in front of her. "I've prepared a comparative analysis of the Carter majority opinion against the court's previous administrative law decisions, which I'd like to submit for the record." A staff member collected the document as Crockett continued. "This analysis identifies 37 specific instances where the Carter majority departs from analytical frameworks the court previously established without explicitly overruling those precedents." The committee room had grown unexpectedly quiet as members realized this wouldn't be the defensive retreat some had anticipated. Crockett wasn't responding as a politician, but as a constitutional lawyer addressing a legal argument. "For example," she continued, "on page 23 of the Carter opinion, the majority states that agency interpretations of ambiguous statutes receive deference only when Congress has explicitly delegated interpretive authority, a standard that directly contradicts the court's holding in Meade, where implicit delegation was deemed sufficient under certain conditions." She turned to another page in her notes. "Similarly, the majority dismisses the agency's technical expertise as a relevant factor in reviewing its interpretation, despite the court's repeated recognition in Keysore, American Hospital Association, and numerous other cases that specialized agency knowledge is a central justification for judicial deference." Alito, visibly recalibrating his approach, leaned forward. "Congresswoman, you're conflating distinct lines of administrative jurisprudence. Carter addressed a question of major constitutional significance under the major questions doctrine, a context where ordinary administrative deference principles are necessarily modified. It was the type of legal counter-argument Alito might offer a fellow justice during deliberations, a significant shift from his earlier condescension, tacitly acknowledging Crockett as a serious legal interlocutor. "That's precisely the analytical inconsistency I'm highlighting, Justice Alito," Crockett responded without hesitation. "The majority opinion in Carter invokes the major questions doctrine without establishing any consistent framework for determining what constitutes a major question, effectively creating a standardless exception that can be applied selectively to override otherwise applicable deference principles." She removed another document, a chart comparing language across multiple decisions. "This comparison tracks the court's evolving characterization of what constitutes a major question across 8 decisions over 12 years. As you can see, the standard has shifted repeatedly without explicit acknowledgement, making it functionally impossible for Congress to predict which questions future courts might deem major when drafting legislation." Committee members could be seen studying the chart with interest, even those typically aligned with Alito's judicial philosophy. The hearing had transformed from political theater into a substantive constitutional law seminar, with Crockett effectively repositioning herself from question to questioner. Alito, recognizing this shift in dynamic, attempted to reassert control. "Congresswoman, with respect, this simplistic chart cannot capture the nuanced development of constitutional doctrine. The major questions principle evolves precisely because each case presents unique statutory and constitutional contexts." "That's a fair observation about constitutional evolution, Justice Alito," Crockett replied, her tone remaining respectful despite the opening his response had provided. "However, doctrinal evolution typically involves explicit reconciliation with existing precedent. My concern, shared by several of your colleagues in dissent, is that the Carter opinion doesn't acknowledge these departures from established frameworks, much less justify them." She turned to another document, copies of dissents from Carter itself. Justice Barrett, though generally aligned with the conservative majority, specifically noted that the majority's approach represents a significant departure from our administrative jurisprudence without adequate explanation of why established frameworks are insufficient. Quoting a conservative justice's own concerns was a masterful tactical choice, preventing Alito from dismissing the critique as merely partisan or ideologically motivated. And Justice Kagan's dissent meticulously identified 17 instances where the majority's reasoning contradicted specific holdings from cases the majority opinion claims to uphold, Crockett continued, turning to the relevant sections she had carefully highlighted. The committee room remained unusually engaged as Crockett systematically worked through specific legal inconsistencies rather than making broad political statements. Even members typically disengaged during technical discussions appeared to follow her clear, methodical analysis. Alito, visibly frustrated that his initial dismissive approach had backfired, attempted another tack. Congresswoman, dissenting opinions, by definition, represent views the court has rejected. The majority opinion in Carter speaks for the court, and that precedent now governs administrative law in these contexts. Absolutely, Justice Alito, Crockett agreed smoothly. The majority opinion is controlling law, which is precisely why I've focused my analysis on internal inconsistencies within the majority opinion itself, not merely the dissent's critiques. She turned to another document, a side-by-side comparison of statements from the Carter majority opinion against language from previous opinions authored by the same justices. These 15 excerpts show instances where the Carter majority contradicts principles those same justices articulated in previous administrative law cases without acknowledging or explaining the shift. This approach, identifying inconsistencies in individual justices' own reasoning rather than making ideological arguments, represented sophisticated legal analysis rarely seen in congressional hearings. Crockett was effectively conducting the kind of rigorous doctrinal critique typically found in law review articles or appellate briefs. Professor Henderson, watching from the gallery, leaned toward former clerk Washington. "She's not playing politics. She's essentially conducting an oral argument," he whispered. "And she's prepared as thoroughly as any Supreme Court advocate I've seen." The cameras caught Alito taking a moment to review the comparison document, his expression suggesting he hadn't anticipated this level of specific textual analysis. When he responded, his tone had shifted markedly from his initial dismissive laughter. "Congresswoman, while I appreciate your attention to the court's administrative jurisprudence, these apparent inconsistencies reflect the necessary adaptation of legal principles to specific statutory contexts. The Carter case presented unique questions about agency authority that required distinguishing prior cases rather than mechanically applying them. It was a substantive legal response, a tacit acknowledgement that Crockett's analysis merited serious engagement rather than condescension. "That's a legitimate perspective on judicial methodology, Justice Alito," Crockett responded. "However, the concern I'm raising isn't about distinguishing cases, which the court does routinely and explicitly, but about the Carter opinion's lack of transparency in acknowledging these departures from established frameworks." She turned to her final exhibit, perhaps the most powerful. "I've compiled a chronological list of 33 instances where you personally, Justice Alito, have criticized other justices in both majority and dissenting opinions for precisely this type of unexplained departure from precedent, including your noted dissent in Bostock where you stated that judicial modifications of established legal doctrine should be explicitly acknowledged and justified, not presented as consistent applications of existing precedent." The committee room fell completely silent. Crockett had effectively used Alito's own judicial philosophy and stated principles against him, highlighting the inconsistency between his criticism of others and the approach taken in his Carter opinion. The cameras caught Alito's expression, a mixture of surprise and what appeared to be reluctant professional respect. The justice who had begun the exchange with dismissive laughter now found himself engaged in exactly the kind of rigorous legal debate he would expect in Supreme Court oral arguments. After a moment of palpable tension, Alito responded in a tone utterly transformed from his opening condescension. "Congresswoman Crockett, while I maintain that the Carter decision is doctrinally sound, I acknowledge your preparation and attention to the court's administrative jurisprudence. Your points about doctrinal transparency deserve consideration, even where we may disagree about their application to this specific case." It wasn't a concession on the merits, but it represented a complete reversal in tone and respect level. Precisely the outcome Crockett had engineered through meticulous preparation and professional presentation, rather than matching Alito's initial derision with her own. The chairman, recognizing the exchange had reached a natural conclusion, attempted to move the hearing forward. "Thank you, Justice Alito and Representative Crockett. We'll now proceed to questions from other committee members." But before he could recognize the next questioner, Alito did something unexpected. "Mr. Chairman, if I might add one brief comment," he said, his tone noticeably more collegial than when the exchange began. "While the Congresswoman and I clearly have different perspectives on the Carter decision's consistency with precedent, her analysis reflects the kind of substantive legal engagement that strengthens our constitutional discourse. The Court benefits from rigorous, good-faith critique grounded in careful reading of our decisions." Coming from a Supreme Court justice who had begun the exchange with open mockery, this professional acknowledgment represented an extraordinary reversal, and a tacit admission that his initial dismissive approach had been misplaced. As the hearing proceeded to other questioners, the fundamental dynamic had shifted. What Alito had initiated as an attempt to publicly diminish Crockett's legal credentials had instead showcased her sophisticated constitutional analysis and forced him to engage with her critique on its merits, rather than dismissing it through derision. Legal observers in the room recognized they had witnessed something remarkable, not just a political exchange, but a substantive constitutional dialogue that had revealed more about both participants than either might have intended when the hearing began. The impact of the exchange between Justice Alito and Representative Crockett extended well beyond the hearing room. Within hours, video clips contrasting Alito's initial dismissive laughter with his eventual respectful engagement had spread across legal blogs, social media platforms, and news websites. What made the exchange particularly compelling wasn't just Crockett's composed response, but the substantive legal analysis she had presented. Rather than engaging in political theater or matching Alito's initial condescension, she had elevated the discussion to a sophisticated constitutional dialogue that showcased her expertise. "What we witnessed was extraordinary," noted veteran Supreme Court reporter Nina Totenberg on that evening's NPR broadcast. Not just because a member of Congress effectively stood her ground against a Supreme Court justice's dismissive treatment, but because she did so through meticulous legal analysis rather than political rhetoric. It was essentially high-level constitutional discourse breaking out in what was expected to be a political hearing. Legal blogs across the ideological spectrum focused on the substance of Crockett's critique rather than just the dramatic confrontation. Conservative legal scholar Jonathan Adler wrote, "While I generally support the Carter decision's limitations on administrative authority, Representative Crockett's analysis of its doctrinal inconsistencies raises legitimate questions about the majority's approach to precedent that deserve serious engagement." From the progressive side, Yale law professor Heather Gerken observed, "Beyond the political theater, Crockett provided one of the most rigorous and specific critiques of the Court's recent administrative jurisprudence we've seen, the kind of analysis usually found in scholarly articles rather than congressional hearings." By the following morning, the exchange had become required viewing in constitutional law classes across the country. Law professors used the clips to demonstrate both effective oral advocacy and the importance of preparation when engaging with complex legal doctrine. "I've assigned this exchange as mandatory watching for my administrative law seminar," Georgetown professor James Mitchell told his students. Notice how Representative Crockett never gets drawn into matching Justice Alito's initial tone, but instead elevates the entire discussion through specific textual analysis and doctrinal comparison. For Alito, the exchange had unexpected consequences. While some conservative commentators initially celebrated his dismissive approach, the full video showing how thoroughly Crockett had responded with substantive legal analysis led to more nuanced reactions. Several former Supreme Court clerks privately expressed concern that his initial condescension had undermined the court's institutional dignity, a perception partially mitigated by his eventual shift to respectful engagement. Justice Alito made a tactical error in assuming Representative Crockett wouldn't have the legal background to respond effectively to his dismissal, observed former Supreme Court reporter Linda Greenhouse. It was a reminder that justices, accustomed to having the final word from the bench, face different dynamics in congressional hearings where their statements can be directly challenged. For Crockett, the aftermath brought enhanced credibility in both political and legal spheres. Legal publications requested permission to republish her comparative analysis of administrative law precedents, while law schools invited her to speak about constitutional interpretation and the relationship between legislative and judicial branches. When asked about the exchange during a CNN interview, Crockett maintained her focus on substance rather than personality. "My concern has always been about constitutional consistency rather than any individual justice," she explained. "What matters isn't the momentary exchange, but whether our highest court provides clear, consistent guidance that Congress can rely upon when drafting legislation." This disciplined focus on legal principles rather than personal conflict further enhanced her reputation as a serious constitutional voice rather than merely another partisan politician, a distinction particularly valuable for a former attorney transitioning to political office. Perhaps most significantly, 3 weeks after the hearing, Justice Elena Kagan cited Crockett's analysis during oral arguments in another administrative law case. As was recently noted in congressional testimony, Kagan remarked while questioning a government lawyer, "Our administrative jurisprudence has developed certain inconsistencies in how we determine when agency interpretations receive deference. How should we reconcile these apparent contradictions?" This direct reference from the bench, a rare acknowledgment of congressional analysis by a sitting justice, represented powerful validation of the substantive quality of Crockett's legal critique beyond the dramatic circumstances of her exchange with Alito. The clearest indication of how thoroughly Crockett's response had shifted perceptions came during a Federalist Society event where a law student asked Alito about the confrontation. Rather than dismissing the question or minimizing the exchange, Alito offered a surprisingly thoughtful response. "While the Congresswoman and I may approach constitutional interpretation differently," he noted, "her detailed analysis of our administrative jurisprudence reflected serious engagement with the court's decisions." That kind of substantive legal critique, regardless of its conclusions, contributes valuably to constitutional discourse. It was as close to an admission of misjudgment as a sitting Supreme Court justice would ever offer, a tacit acknowledgment that his initial dismissive approach had been inappropriate given Crockett's actual legal expertise. For constitutional scholars, the entire episode represented a rare moment where substance had ultimately prevailed over theatrics in a political setting. What had begun as an attempt to publicly diminish a legislator's legal credentials had instead showcased those very credentials while raising legitimate questions about doctrinal consistency that even those who disagreed with Crockett's conclusions acknowledged merited serious consideration. Professor Henderson, who had witnessed the exchange firsthand, later told his constitutional law class, "What made Representative Crockett's response so effective wasn't just her obvious preparation, but her strategic choice to elevate the discussion rather than respond in kind to Justice Alito's initial tone. She essentially forced a transformation from political theater to substantive legal discourse, and in doing so, revealed more about both participants' approach to constitutional interpretation than either might have intended." As the substantive policy debate about administrative authority continued in both legislative and judicial venues, the exchange between Alito and Crockett had established a new standard for how constitutional discourse between branches might ideally function, grounded in specific textual analysis and doctrinal consistency, rather than political posturing or institutional defensiveness. The repercussions of the exchange between Justice Alito and Representative Crockett continued to reverberate through both legal and political spheres long after the hearing concluded. What had begun as a momentary confrontation evolved into something with lasting implications for constitutional discourse and institutional relationships. Within the legal academy, Crockett's analysis catalyzed renewed scholarly attention to consistency in administrative law doctrine. Harvard Law Review dedicated a symposium issue to examining the questions her critique had raised, with contributors from across the ideological spectrum addressing the tension between doctrinal evolution and predictable legal frameworks. Representative Crockett's confrontation with Justice Alito has sparked the most productive academic conversation about administrative jurisprudence we've seen in years, noted constitutional scholar Cass Sunstein. By focusing on specific textual inconsistencies rather than broad ideological complaints, she identified methodological questions that transcend political divisions. This scholarly engagement extended to law school classrooms, where the exchange became a case study in both constitutional advocacy and the relationship between branches of government. Students analyzed not just the substance of the legal arguments, but also the strategic choices both participants had made in presenting their positions. The Alito-Crockett exchange demonstrates how preparation and substantive knowledge can transform power dynamics in institutional settings, Professor Rebecca Chen told her constitutional law students at Columbia. It's a masterclass in maintaining professional composure while effectively redirecting a conversation from dismissive treatment to substantive engagement. For Crockett personally, the aftermath brought opportunities to influence constitutional discourse beyond traditional political channels. The Yale Law Journal published her expanded analysis of administrative deference principles, which was subsequently cited in multiple federal circuit court decisions grappling with post-Carter administrative law questions. When interviewed about this unusual impact for a first-term representative, Crockett maintained her focus on institutional rather than personal considerations. The questions about doctrinal consistency I raised aren't partisan issues. They're about whether our constitutional system provides predictable frameworks that all branches of government can rely upon, regardless of political composition. This consistency in emphasizing constitutional principles over political advantage enhanced her credibility with legal scholars across the ideological spectrum. Conservative legal theorist Randy Barnett, though disagreeing with Crockett's ultimate conclusions about administrative authority, acknowledged the value of her approach. Representative Crockett has demonstrated how legislative oversight can contribute meaningfully to constitutional discourse when grounded in serious textual and doctrinal analysis, rather than political talking points. For Justice Alito, the exchange prompted more subtle but nonetheless significant adjustments. Court observers noted that his majority opinion in the following term's major administrative law case, Westmoreland v. Department of Energy, contained unusually detailed discussion reconciling the decision with previous precedents, including explicit acknowledgement of apparent tensions and their resolution. Justice Alito's Westmoreland opinion shows a marked increase in doctrinal transparency, observed Supreme Court reporter Amy Howe. Whether consciously or not, he seems to have internalized Representative Crockett's core critique about the need to explicitly acknowledge and justify departures from established frameworks. Perhaps most significantly, the exchange influenced how Congress approached its oversight role regarding the judiciary. The House Judiciary Committee established a new protocol for hearings involving judicial officers, emphasizing substantive legal analysis over political positioning and ensuring members had access to specialized staff support when preparing questions on complex constitutional issues. The Alito-Crockett exchange demonstrated both the pitfalls of treating these hearings as political theater and the potential value when they involve serious constitutional discourse, explained Committee Chairman James Williams. We're trying to institutionalize the latter approach while discouraging the former. 6 months after the hearing, Crockett's substantive critique received perhaps its most meaningful validation when the Supreme Court granted certiorari in Regional Transit Authority v. EPA, a case directly addressing questions about consistent application of administrative deference principles that Crockett had highlighted in her exchange with Alito. The court's order specifically requested briefing on whether and how the court should reconcile apparently inconsistent approaches to administrative deference across recent decisions, language that closely echoed Crockett's critique during the hearing. When the eventual decision came down, it revealed the real-world impact of what had begun as a momentary confrontation. Writing for a 6-justice majority that crossed ideological lines, Chief Justice Roberts explicitly acknowledged the need for greater doctrinal clarity. Recent criticism from both within and beyond the court has rightfully highlighted inconsistencies in our administrative jurisprudence that have created unnecessary confusion for Congress, administrative agencies, and lower courts. Today's decision attempts to provide a more coherent framework that maintains appropriate judicial oversight while respecting Congress's delegation choices and agency expertise. While not directly citing Crockett, the opinion's approach, systematically addressing specific inconsistencies she had identified, reflected clear influence from her critique. More remarkably, Justice Alito joined this majority opinion despite its implicit acknowledgement of the valid concerns he had initially dismissed with laughter. For legal observers, this outcome represented the most meaningful victory from the confrontation, an actual refinement of constitutional doctrine resulting from substantive exchange between branches of government. When asked about the regional transit decision during a judicial conference panel, Alito demonstrated how far the discourse had evolved from his initial dismissive approach. While reasonable minds can differ on specific applications, I believe we all recognize the value of doctrinal clarity and transparency, he noted. Our constitutional system functions best when each branch understands how the others interpret their respective authorities. For ordinary Americans watching these developments, the entire episode offered a rare glimpse of how constitutional governance can function at its best, when substantive analysis prevails over institutional defensiveness or political positioning. Professor Henderson, invited to reflect on the exchange's legacy for a C-SPAN documentary on inter-branch relations, observed, "What began as an attempt to publicly diminish a legislator's legal expertise instead revealed the potential value of informed legislative engagement with judicial doctrine. Representative Crockett transformed what could have been merely a viral moment of conflict into a substantive contribution to constitutional development, demonstrating how preparation and professionalism can elevate our governance discourse even in highly charged settings." For students of constitutional government, the Alito-Crockett exchange ultimately offered an important lesson about institutional relationships in our separated powers system. As Yale Law Dean Heather Gerken noted in her commencement address that spring, the most effective check on power isn't angry confrontation, but substantive engagement that reveals contradictions and inconsistencies in how that power is exercised. Representative Crockett's response to Justice Alito demonstrated that speaking truth to power is most effective when that truth is meticulously documented, professionally presented, and focused on principles rather than personalities. It was a lesson about constitutional discourse that transcended the particular legal issues involved, a reminder that in a system where different branches exercise separate but interdependent powers, the quality of their engagement significantly affects governance outcomes regardless of ideological perspectives. As for the protagonists themselves, both Justice Alito and Representative Crockett had revealed more about their approach to constitutional interpretation than either likely intended when their exchange began, a transparency that ultimately strengthened rather than diminished public understanding of how our fundamental law evolves through institutional dialogue across separated powers. If you found this analysis of constitutional confrontation valuable, please like this video and subscribe to our channel for more in-depth examinations of how our system of separated powers actually functions. Hit the notification bell to stay updated on future videos exploring the complex relationships between our branches of government. Your support makes this kind of substantive analysis of American constitutionalism possible.